This is an extremely important video to make sure everyone in the Second Amendment community understands how to apply the right to keep and bear arms and the Supreme Court decision in NYSERPA versus Bruen to so-called assault weapon bans and the so-called large capacity magazine bans, which are just standard magazines and, of course, semi-automatic rifles. Bottom line is, I want to make this clear because I think there's been some people that have been talking in a way that's harmful to the Second Amendment, and I know they're not doing it on purpose. I know they're confused, and I'm going to fix that right here, right now with this video, so everyone in the Second Amendment community understands, including judges, law clerks, and lawyers that watch this channel, exactly how to apply the Bruen decision when it comes to these so-called gun ban cases. Stay tuned. I'll explain. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, best-selling author, proud American gun owner, constitutional attorney, and member of the United States Supreme Court Bar. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And feel free to join us on Twitter at Four Boxes Diner. All right, folks, here's the story. I want to make this crystal clear. This is extremely important that this does not get confused. There are still certain gun bans out there in America. They're slowly but surely being struck down. For example, in just the last month or so, 2 so-called assault weapon bans in Colorado were enjoined, meaning they were prevented from being enforced going forward. One in Superior, one in Boulder, by 2 separate judges, one an Obama-appointed judge, one a Joe Biden-appointed judge. Both applying NYSERPA versus Bruen said that no gun ban, such as AR-15 bans or semi-automatic rifle bans, are constitutional under the Second Amendment. And I want to make sure that we understand the process to reach that conclusion, because there's some people I've heard talk about creating a more complex system which is unfavorable to the right to keep and bear arms and is also not right. So I want to make sure this is cleared up right here and right now, so any kind of potential mistake made against the Second Amendment does not get made in the first place. All right? Here's how it goes. To begin, when you're confronting a ban on so-called assault weapons, which are really nothing more than semi-automatic rifle bans. Now, when we talk about semi-automatic rifle bans, that's not my language. That's not your language. That is actually the language used by then Judge Brett Kavanaugh, today Justice Brett Kavanaugh, when he wrote a case called Heller 2 in the D.C. Court of Appeals, which he dissented from the uphold of the ban, but he wrote the definitive position, I think, on so-called assault weapon bans, and he specifically calls them semi-automatic rifle bans. So I think that when you're talking about so-called assault weapon bans, make sure you use the proper language, referring to these as semi-automatic rifle bans, not AR-15 bans, not AR pattern bans, semi-automatic rifle bans, number one. So make sure you're using the right terminology when you write your opinions, when you write your bench memos, when you write your articles, when you write your op-eds, whatever it is, get that right first and foremost. Redefine the propaganda term assault weapons to semi-automatic rifles. That's step 1. Step 2, now let's walk through the law based upon Heller, McDonald, Caetano, and Bruen, the 4 Supreme Court cases. It's quite clear. Ready? Bottom line is this. Commonly possessed, commonly owned firearms in the United States today are protected under the Second Amendment. They are protected arms. This is the legal process by which we undertake that fundamental inquiry, though. First of all, we know that in 1791, a bearable arm was what was being protected, a bearable arm. Now, a bearable arm is defined largely by a Tory lexicographer in 1791 by the name of Samuel Johnson. Samuel Johnson was the English dictionary maker. We call them lexicographers, but he is the definitive guy at the time of the founding, 1791, that the founding fathers used, because at that time in 1791, which is the year that the Second Amendment was ratified, there were no American-based dictionaries of English. The first American-based dictionary of American English comes out in the 19th century by Noah Webster, which we now know as Webster's Dictionary. But Noah Webster did not write the American English Dictionary until after the American Revolution, after the Constitution had been adopted. So in 1791, we look at the definitions in a dictionary from Samuel Johnson, an English lexicographer, and he defines arms as anything that can be used offensively or defensively. That was what Samuel Johnson said. Obviously, semi-automatic rifles can be used offensively or defensively. Relatedly, because the text of the Second Amendment talks about the right to keep, which means to possess and to have, and the right to bear, which means to carry, the traditional understanding at the time of the founding is that what the arms are being protected under the text of the Second Amendment are those that are bearable, those are that can be carried, as distinguished from, let's say, artillery pieces and whatnot. There are some debates about that, but it's not worth getting into right now because none of those other debates are worth talking about unless and until we have a Supreme Court decision that says that AR-15 semi-automatic rifle bans are unconstitutional, as well as so-called standard magazines that hold more than 10 round bans are unconstitutional as well. So one step at a time. We have to do things incrementally. Now let's continue with the word arm. We know in 2016 the Supreme Court issued a decision called Caetano versus Massachusetts. In that decision, they talk about stun guns being arms. Now, stun guns being arms is important for several reasons, one of which is stun guns are not firearms. Stun guns are something other than the firearms. They work differently. So it's very important to understand that based on the Supreme Court's decision in Caetano, weapons that are not just firearms can also be protected arms. I repeat, based on the 2016 Supreme Court decision in Caetano versus Massachusetts, weapons and arms that are not just firearms may also be protected under the definition of arms, as in the right to keep and bear arms, can also be protected under the Second Amendment because stun guns are not firearms, and yet the Supreme Court said they were protected. That's critically important to understand. On a related note, we also know historically that non-firearms are also arms for Second Amendment purposes based on the history. Remember, the Supreme Court repeatedly says that to understand the scope of the Second Amendment, you have to look at the text of the Second Amendment, which we do, and then you also look to the related history associated with the Second Amendment to understand what's protected. If you go back to our founding era, immediately before the start of the American Revolution, we had the Boston Massacre events. In the Boston Massacre, what happened was Americans, Bostonians, carrying arms, but not firearms. They were carrying bricks and bats and other weapons, but not firearms. They surrounded a customs house that was protected by British officers. The British officers, for various reasons, we don't really know, history doesn't tell us exactly what happened, it's confusing, but they opened fire and they kill several Americans. These are the first Americans killed in the American Revolution. Many consider that to be the case, by the way. And basically, during the trial of the Boston Massacre, which the British officers who killed the Americans were put on trial for murder, John Adams, one of our earliest founding fathers and most influential, represented as the lawyer for the British officers. He conceded and argued in court that, yes, Bostonians and Americans are allowed to have arms in public. They're allowed to bear arms in public, and we do not deny that the Bostonians had the right to have arms out front of the customs house. It's just they weren't supposed to use them offensively toward the British officers, which Adams' case was that's what happened. But set the issue aside, the fundamental point is that Adams admitted and conceded that under American law at the time of our founding, non-firearms were deemed arms, and you were allowed to have those arms in public based upon Adams' conversations and statements to the court in the Boston Massacre trial. So again, that's why Caetano and that history is important. Now let's go beyond that. So once we know we're talking about something that's an arm that can be used offensively or defensively, and something that's bearable, meaning you can carry it, which is no debate if those things mean arms. There may be other things, but at a minimum we know this is what arms mean. That certainly includes semi-automatic weapons such as semi-automatic rifles, which are obviously arms. They're actually firearms. And of course they can be carried, which means they are bearable arms. So once we conclude we're talking about a ban, a legislative or legal ban on a bearable arm, which semi-automatic rifles clearly are, we know that they're now covered by the text of the Second Amendment. Now, this is important because let's say someone banned a coffee mug. Well, that would not be usually considered a bearable arm. It's a coffee cup, right? So, or a cell phone. So that might be legal. It might not be legal, but the fact is banning a coffee cup or banning a cell phone would not fall in all likelihood under the textual meaning of the right to keep and bear arms. And because of that, bans on coffee cups and bans on cell phones or bans on, let's say, a camera would likely not trigger Second Amendment protections because they're not bearable arms. So, but now that we're talking about semi-automatic rifles, those are bearable arms. So once you know you're talking about something that's touching on or you're covered by the Second Amendment, how do you know whether or not it's protected based on the Supreme Court's language? Well, this actually goes all the way back to the United States versus Miller, that case in the 1930s, which we are going to talk about at some point in detail because it's worth just breaking down for you to understand it. But even U.S. versus Miller says that weapons that are commonly owned by Americans are protected arms. That was repeated in Heller, McDonald, Caetano, and yes, Nyserpa versus Bruen. So the fundamental point is this. Understand it this way. If you look at the text of the Second Amendment, you have the prefatory clause, which is one of the reasons, not the only reason, but a reason why we want to protect the operative clause. So again, think of the Second Amendment. A well-regulated militia, etc., is the prefatory clause given a purpose, one purpose, not the only purpose, one purpose of why we have the operative clause, which is the right of the people to keep and bear arms shall not be infringed. So all the way back to Miller, going all the way up to Bruen, basically the idea is that Americans have the right to keep and bear arms for many reasons: self-defense, for hunting, for fighting off domestic insurrections, for thwarting foreign tyrants, for thwarting government oppression, on and on and on. But one of the reasons is to make sure that you have a well-regulated militia in the United States. Because the way the militia service works is you and I have guns, you and I have weapons, and we are supposed to bring those weapons with us if we ever are called out for militia duty or militia purposes. That was the idea in 1791, that the armed citizenry, if needed, could be called out to step up to fight criminals, tyranny, whatever it is, serving the militia. The bottom line is we would bring our own guns. The government wouldn't give us the guns. We would bring our own guns. So therefore, weapons commonly owned by Americans are viewed as militia weapons, and therefore they are protected. So you can think of it that way. But again, the bottom line is this. If a bearable arm is commonly owned or commonly owned by Americans or commonly possessed by Americans for lawful purposes, that's the end of the inquiry. So let's talk briefly about that test. Why is that test good for us? This test is extremely good for us, and I'll tell you why. Because the standard is if a firearm or if a weapon is commonly owned by Americans for lawful purposes, what is not considered in that question? I'm going to give you a moment to think about it. If I ask you if a weapon is commonly owned by Americans for lawful purposes, the answer to that question is going to be yes or no. What is one thing that is not considered when I ask you that question? The answer is this. The question does not consider in any respect, shape, or form the criminal misuse of firearms. Think about it. If I ask you, is that semi-automatic rifle commonly owned by Americans for lawful purposes? The answer is yes. Tens of millions of people own AR pattern firearms, semi-automatic rifles, tens of millions. That's the answer. The answer is yes. Now, if someone comes out and says, wait, people misuse semi-automatic rifles to commit crimes. They kill people. They do bad things with guns. And the answer is stop. Irrelevant. What is the question? Are these guns commonly owned by Americans for lawful purposes? Yes or no? If the answer is yes, game over. Game over. It doesn't matter that people misuse guns. It doesn't matter that psychopaths misuse guns. It doesn't matter that anyone misuses guns. It is not relevant to the legal test. That's why the common use test is so good for us, because it prevents the anti-gunners from going into court being like, guns kill people, guns are bad, because it's irrelevant for the purposes of the law. For the purposes of the law, for the application of the Second Amendment, because all that matters if it's commonly owned by Americans for lawful purposes is protected arms. Period, full stop. You cannot ban it. That is very, very powerful standard and a very powerful test. It's game over. So again, how many semi-automatic rifles are there in the United States? Well, based upon the National Shooting Sports Foundation's best estimates, they have over 20 million. According to the largest national firearms survey ever conducted of firearm owners in 2021, published in 2021, then again in 2022, by William English, a professor at Georgetown University. He has, I think, upwards of 40 million people own or have owned semi-automatic rifles that are AR pattern style rifles. So somewhere between 20 and 40 million is the number of AR style pattern or AR pattern rifles, semi-automatic rifles we have in the United States right now. So those are clearly commonly owned by Americans for lawful purposes because they're used for sporting purposes, they're used for hunting, they're used for self-defense, they're used for protecting crops and on and on and on, and self-defense. We know this. I also want to mention, to put a little bit of compare and contrast here, that in Caetano, where they said that stun guns are commonly owned by Americans for lawful purposes, how many stun guns were in civilian hands in 2016, according to the concurrence by Justice Alito in the Caetano case before the Supreme Court? Well, Justice Alito said that there were 200,000, I repeat, 200,000 stun guns in civilian hands in 2016, and that was deemed that stun guns were commonly owned by Americans for lawful purposes. I could tell you 200,000 stun guns is dramatically a smaller number than the tens of millions of AR pattern firearms, semi-automatic rifles in the United States today. So obviously under the common use test, semi-automatic rifles are protected. Now, the last point, and in some ways this is the most important point to understand, this is where there's mistakes, I think, potentially being made here. If you read the Bruen case, when they talk about other gun regulations, not gun bans, but other gun regulations, such as restrictions on the right to carry guns, whether or not you have the right to make guns, regulations on who gets a gun license, whatever it is, the Supreme Court says that if the Second Amendment is triggered, we then look to see if there is a historical analog in 1791 to the modern day gun law. So if you have a gun control law being challenged today as violating the Second Amendment today, the Supreme Court says that you're to compare that gun control law to any gun control laws that existed in 1791 to see if there's a historical analog to justify the modern day gun control law. And if the answer is no, there is not, then the modern day gun control is thrown out of court as unconstitutional. All right, here is the mistake that you should not make. Mission critical, star this. If you are litigating, if you're a judge, if you're a law clerk, star this point. When you are dealing with gun bans, when you're dealing with magazine bans, your only historical test that you have to engage in is whether or not Americans commonly own firearms for the purposes of lawful purposes. That's it. Once the answer is yes, they are protected, there is no second step. There is no second step that you have to say, well, is there historical analog in 1791 to this gun control law? You do not take that second step when you deal with gun bans. It is a single question of common possession. The second step of is there a historical analog to a gun ban in 1791 is not undertaken. And why is that? It is because the historical analysis, the understanding of American history, when it comes to gun bans or bans on arms, is implicit. It is baked in. It is part of the common use test already. So by applying the common use test, which is commonly owned by Americans for lawful purposes test, and answering the question yes, that is game over. There is no next step, because the next step in the other gun regulation context is a historical test, saying, well, now let's look historically. Is there a analog historically to the regulation we're talking about today? Yes or no? But when you're dealing with gun bans, the historical test is specifically commonly owned by Americans for lawful purposes. That is the historical test. So by asking that question, you are effectively doing a historical test, but it is a one-step test that is the only thing you have to do. Once the answer is yes, semi-automatic rifles are protected arms, it's game over. You can't ban them. Done. There is no, now let's go and take another step and give the anti-gunners another chance to win by seeing if there's a historical analog that they can come up with in 1791 to show that guns are banned. No, That second step does not exist. That does not exist in the context of gun ban cases. You only look at the common use. And by the way, with respect to magazines, we know that magazines are also considered arms because they're an essential component of the firearm, meaning these are components that allow you to hold excess ammunition as part of the firearm and to reload. And in some guns, of course, you can't even fire without a magazine. I know that's not all of them, but some also you can't even fire a gun without a magazine. Makes it a magazine another essential component, makes it a protected arm under the Second Amendment, and therefore the same test applies. And by the way, and we know that magazines that hold more than 10 rounds are commonly owned by Americans for lawful purposes because according to, at a minimum, the Georgetown professor William English's study of firearm ownership, we know there's over, ready for this, folks, 500 million. I repeat, 500 million with a B, more than 500 million magazines that hold more than 10 rounds in the United States based on Professor English's work, which I can link to down below. We've talked about it in other contexts as well. So obviously 500 million arms in terms of magazines holding more than 10 rounds is certainly a much, much, much bigger number than the 200,000 stun guns that were protected as commonly owned by Americans for lawful purposes in the Caetano case in 2016. Okay, I hope you learned a little bit something here today. I know it was a little geeky, a little bit long, but mission critical to get this right. You do not want to screw this up and give the anti-gunners yet another crack at the apple to justify their gun bans by adding historical tests that do not exist in the Supreme Court precedent or in the Supreme Court jurisprudence. Do not let them go out and make up new tests that we have to meet. That's not how it works. And never forget the fact that at the end of the day, the government, according to Ninth Circuit versus Bruen, it's the government that bears the burden to justify all these gun bans under the Constitution and historically and beyond, and they simply can't do that. Okay, hope you learned something. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Foxes Diner.
Orders up. Table 2A.